So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital
Today we're going to be talking
revolution.
about a new Canadian law coming down the pipeline that is going to ban strikebreakers, and this is pretty important. So, strikebreakers or scab labor often refers to temporary or replacement workers who are hired by a company to fill in for employees who are on strike or involved in a labor dispute. Whether or not a company can hire such replacement workers really depends on the laws and regulations where this happens. In many countries, companies have the legal right to hire replacement workers during the strike, like in the United States. And these workers are called strike breakers or replacement workers. But using these workers is a controversial practice and can contribute to increased tension between employers and employees. And frequently, people who cross the picket line, people who break the strike, are met with derision or much worse, tomatoes, eggs, anything, right? When they're breaking the picket line. In some jurisdictions, there are restrictions on the use of replacement workers, and there are certain conditions. In some countries, they may require companies to provide notice to the striking workers or to make sure that they're bargaining in good faith. In the United States, it's generally legal. The legal framework regarding the use of replacement workers, varies by state to state, and there are federal laws that govern certain aspects, like the National Labor Relations Act, which protects the right of employees to engage in concerted activities for the purposes of collective bargaining or other mutual aid or protection. But it doesn't prohibit employers from hiring replacement workers during a strike or labor dispute. Uh, so let's get to this new law. It's Bill C-58, and there are actually already provisions in the province level in Canada for banning strikebreakers, specifically in Quebec and British Columbia. They have similar legislation to C-58. Ultimately, this bill amends the Canadian Labor Code. It's the primary industrial relations labor code in Canada, and this amendment will prohibit an employer from employing any employee who or person who performs management functions, if they're working in a union capacity, any contractor other than a dependent contractor or employee of another employer, or an employee of the bargaining unit that is on strike or locked out. So even if this employee, supported the company and was, against the union and wanted to work and was, a current employee of the employer, but that their bargaining unit was on strike, they could not work. Which that's what common. There are oftentimes scabs or strike breakers that are hired to replace people. Absolutely, that happens all the time. But there is another subset that is not actually consistent with the union, and they just come into work and continue to just cross the picket line in that manner. And this law actually prohibits that, which is, in my opinion, quite interesting and curious. There is an exception to the law, of course, and that's when services or situations are present where life, health, or safety of any person, threat or destruction could happen, and the employer is unable to deal with the situation other than by using strike breakers. But I mean, for one, I think that that's a situation where, okay, I understand, and that's sort of like the minimum service levels that we covered in previously with respect to the British minimum service levels law that might prohibit a strike altogether in many respects. And really, this amendment to the code specifically surrounds, the majority of this amendment seems to specifically surround this situation where life and death is at stake and so forth. Um, you know, this could come into force in about 18 months, and of course, federally regulated employers will have to comply. I don't know. I mean, I think that I understand the idea that the Canadian government does not want to see strikebreakers, and I think that there is a level of understanding as to what the Canadian government is trying to do with this law, but it does interfere with the company's ability to associate with who it wants to. In the United States, it'd be the right to association. Of course, they don't follow our Constitution, and they don't have any need to. But there is that concern, right, that they're limiting other people's right to association in favor of a certain person's. And I find that to be quite scary personally, and not something that I would want to be connected with. Let me know what you think in the comments down below. Is this legitimate? Is this a reasonable thing? You can also find a link to this article, of course, the full article, so you can read the whole thing for yourself. And the comments down below or in the description. And please like, share, and subscribe, and we'll see you on the next video. Bye, guys.